If you're here, it's probably because you've been arrested for theft or just received a summons for theft. Either way, you're wondering, what is LARS 1467? That is the actual statute that the police officer is accusing you of violating. In other words, the cop thinks you broke the law. The law for which he thinks you broke is the theft law, which was written by lawmakers and given the number 1467. When he gave you the summons or made an arrest, he had to write the statute number on your ticket or arrest paperwork so the judge and the prosecutor can know why you were arrested. Just because the cop thinks you committed a theft doesn't mean you're going to get convicted of it. Within weeks after you get the summons or arrest, the police officer will send his reports about the incident to the prosecutor's office. The prosecuting attorney will look at the case and determine how he wants to charge you formally. This is more important than the charge the officer wrote down. This is when you want your criminal defense attorney in contact with the prosecutor. Don't wait until your court date comes to hire a lawyer the day before. Theft cases can all be different factually. At the Barkemeyer Law Firm, we've seen it all. We've seen theft charges involving misappropriation of hundreds of thousands of dollars in building construction to switching price tags at Walmart. So I realize you could be one of those or in the middle. That's why in this video, I'll try to break down some important points that should apply to you no matter what you're accused of. According to the theft statute in Louisiana under 1467, theft is the misappropriation or taking of anything of value which belongs to another, either without the consent of the other to the misappropriation or taking, or by means of fraudulent conduct, practices, or representations. Blah, blah, blah. So what does this actually mean? Look, theft is basically 1, keeping something from someone else, either by taking it from them or failing to let them have possession of it. 2, that the thing has value. 3, that the taking was done without their consent, or you got their consent, but you did so by using lies or manipulation. And 4, you had intent to keep the thing permanently. And I know what you're thinking. Oh, I could just say that I was going to give it back. The problem with that defense is that it may not be believable, and it would just become an unauthorized use charge, which can be just as bad. So let's do some examples. I'll try to use some lifelike hypotheticals so we can make this a little bit more real. Let's say Cassidy works at Victoria's Secret as a cashier. A lot of shoplifting by customers goes on at Victoria's Secret, by the way. But we'll just focus on Cassidy for now. Cassidy and her BFF, Caitlin, decide they have a scam to get some merchandise for cheap. Caitlin comes in and picks out $2,000 worth of merchandise from the racks and goes to check out with Cassidy. Cassidy rings up the items for $2,000 plus tax, but decides to apply an 80% discount that she knows is a recent glitch in the system. The total comes to just about $400. Eventually, after doing this many times, the manager figures out the glitch, reviews transactions, pulls videos, calls the police, and Cassidy is arrested. Caitlin is also arrested as a principal to theft. They are both charged with felony theft because they kept $1,600 from Victoria's Secret that was owed to the store. If the value of the taking is $1,000 or more, the charge is felony theft. They're looking at potential prison sentence of up to 5 years. Felony theft is a probatable charge, however, that determination would be made by the judge. Now let's do the most common misdemeanor theft example of all, Walmart shoplifting at the self-checkout. Despite there being hundreds of cameras in the sky at Walmart, people still attempt to swipe goods with smooth hand tricks at the self-checkout. The problem is that Walmart has no mercy. Let's say Tiffany accidentally put an item in her bag that didn't ring up. Watch out, because Walmart is going to walk her to the back. Once she gets to the back room, she explains that she didn't mean to not swipe the items because she was distracted because her 2-year-old wouldn't stop crying. She said she paid for $200 worth of other items. Why would she not pay for the remaining items? She even offers to pay for the items, but they decline leniency. They call the sheriff to come over and give her a summons. So this is where many people go wrong. They figure, oh, it's just a ticket. I'll just go to court and pay it like a speeding ticket. Wrong. This is a criminal charge punishable by up to 6 months in jail. You were given a ticket instead of being booked in jail because Louisiana has serious jail overcrowding issues at the moment. You will have court dates in criminal case alongside those charged with armed robbery and murder. Not to mention that you'll now have a theft on your criminal background for the world to see if it is not properly handled in court. Like I said earlier, the difference between misdemeanor theft and felony theft is the value of the alleged stolen property. If the value of the alleged stolen item is less than $1,000, then the charge should be a misdemeanor theft. The difference is important because the value determines the sentencing range if found guilty. Misdemeanor theft carries a sentence of up to 6 months in jail, while felony theft, when misappropriation or taking amounts to a value of $1,000 or more but less than a value of $5,000, the offender shall be imprisoned with or without hard labor for not more than 5 years. If the value is $5,000 or more but less than $25,000, the sentencing range is 0 to 10 years in prison and or fine of up to $10,000. When the value of the item is $25,000 or more, the sentencing range is now 0 to 20 years in prison and a fine of up to $50,000. In any theft case, the prosecutor must be able to prove the value of the item. If he can only prove the item is worth less than $1,000, then the charge should be a misdemeanor theft. I hope this video helps you understand theft and the statute a little bit better. Please keep in mind one thing. Just because you did it doesn't mean you're stuck with it. We're criminal defense attorneys. Our job is to help people get the best result no matter what they did and no matter how bad the facts are against them. We aren't here to tell you what is right or wrong. We're not your mommy or your daddy. We're not here to tell you to confess your sins like they do in church. We work in the criminal justice system. This is no church. And we judge nobody. Most people may not understand this, but that's okay. The bottom line is we like to help people that need it the most. We supply the power and the strength needed to stand up against the police and the prosecutors that are teaming up to push you around. If you've been charged with theft in Louisiana and need to hire a lawyer, feel free to give us a call. We have offices all throughout Louisiana, so we're always close by.